You please feel free to take off the mask if you don't, if you would like to. Good morning, Advocate Crutchfield SC.
Good morning, Chief Justice. Good morning to all the commissioners.
Are you well?
I am well indeed. Thank you, Chief Justice. And you, I trust you are as well, and the commissioners?
We're very well, thank you. You hold several degrees, am I right? And a diploma.
Yes, I hold 2 degrees. Yes, 2 degrees and several diplomas, yes.
Yes. And what did you do after completing your second degree? Very briefly.
Excuse me, Chief Justice, my second degree.
After completing your second degree, what work did you do?
Chief Justice, I finished my second degree was my LLB. I finished my LLB at the end of 1988, and I started my pupillage the following year in the July. For the next 6 months until the December, I did pupillage. And then in December of 1989, I joined the Johannesburg Society of Advocates, and I've been practicing there ever since.
So for how many years did you practice as a junior, and for how many as senior counsel?
I practiced as a junior for approximately 27 years. And my datas were recommended by the Bar Council in May of 2016. And they were signed and conferred by the state president 2 years later in June 2018. So obtaining my letters in and of itself was a 5-year process.
Yes. And for how long in all have you acted as a judge of the High Court?
Chief Justice, I've been acting on and off, thank you to the JP,
Sure.
Since February of 2016. So I've done 64 weeks in total. That's by my calculation. And during that time, I've been lucky enough, privileged enough to act in all of the courts that the Gauteng division offers. So I've sat in Johannesburg, I've sat in Pretoria, I've sat in the motion court, unopposed and opposed. I've sat on appeals coming from the magistrates court, both criminal and civil. I've sat on full court, civil and criminal appeals, and I've sat in the tax court, and of course in the civil trial court. So I've covered the range of what is available in our courts. And my submission is that I'm properly qualified and I'm properly experienced and adequately so, if the Commission considers it appropriate to accept my appointment.
Thank you. JP, before I invite you, let me just have a list of my colleagues, my other colleagues who would want to put questions to the candidate. Colleagues, please give me your names. And as I do, President Maya, please jot them down. And you, Judge President Lambo, since you are on the ground, if you could also just jot down the names as they are mentioned.
Matansela.
Liam.
Thing.
Bofo.
Maturo Tlepu.
Makwanisha.
Tepe. Schlemmer.
Thank you. JP, over to you.
Thank you, CJ. In terms of this task you've given me, the commissioners were very fast. I only have 1, 2, 3, 4, 5, 6 names. I think you have more than that. But I just thought, let me make that disclaimer up front. I missed some other names, so I'm sorry about
That's
it.
fine. If I happen to leave, I'll mention a name or two that are left so that you can take care of that, together with President Maya, of course.
Thank you very much, Chief Justice. Good morning, Advocate Crutchfield.
Good morning, JP.
You've said at the end of your questioning by the Chief Justice that you think you're experienced, you've acted in almost all the work areas of the division, and you're ready.
Indeed, yes, JP.
Right. Mine is just to confirm to you that I've given the commission the spreadsheet of work allocation since you started acting. It's 64 weeks. You've done your fair share of the heavy lifting work. I think that's all I'll say. The commission will ask you what I mean by heavy lifting. That is, you've done 7 solid weeks in the opposed motion court. And then you've done the special motions. You've done 3 special motions. Those are the complex special motions that don't go into the opposed motions.
Yes.
Is that correct?
JP, if I may.
Yes.
At this stage, I have 2 reserve judgments that are outstanding.
Yes.
One of those is a special motion, and it dates from the 30th of November.
Yes.
It sounds an excessive period of time. I'm aware of that. But it is a very big matter. It actually includes 4 separate applications. They overlap, they interlap. There are complex and difficult issues that arise. They deal with Anton Pillar orders. The main application is the return day of an Anton Pillar application. It covers issues of unfair trade, unfair competition, issues of restraints of trade, issues in respect of the Anton Pillar itself. Also, there are questions of urgency in respect of all the matters. The other matters deal with restraints of trade, unfair competition, and there is also possibly an opportunity to develop the law based on the Bierke judgment in the Constitutional Court in 2017.
Okay. Thank you for that notification.
My apologies, Chief Justice. And then there's one that follows from, JP, from the 8th of, in fact, the 9th of December, but it's the big one that is delaying the second one. But I give you a solemn undertaking, they will be delivered within the 6-month period.
Okay. You've sat in 6 full court appeals. Did you write any of those judgments?
Yes.
How many?
JP, I wrote the last 2 that I sat in, and I wrote 2, 3 of the previous ones. And I'm sitting a full court appeals, civil full court appeals next week, and I'm going to write the full court appeal on Monday, and I have a criminal appeal on the Thursday, a 2-bench appeal, and I'll write that judgment as well.
Yeah. My last question is, you've been acting on and off. The longest stint was, I think, was a term, if I'm not mistaken, the 3rd term of 2020, where you acted for 8 solid weeks.
Yes,
That was a statement of intent to see if you could last, if you are allocated a permanent judge's workload, right? So you are happy that you've acted enough, and coupled with your experience as a silk, you're happy that you are more than ready to take up a permanent appointment.
that is my view, JP.
In particular, taking the work of the division, you've acted in both the complexity and the volume.
Excuse me, JP.
The complexity of the work we deal with, as well as the volume thereof.
Yes.
Thank you. Thank you very much, Chief Justice.
Thank you, JP. MEC?
Thank you so much, Chief Justice. Good morning, Advocate.
Good morning, sir.
I listened attentively to your justification for the delayed judgment. And I'm very sympathetic, but the reason why people go to court is because they want justice to be served. Excluding what you have just said, what is your attitude primarily to people who delay their judgments?
Judgments should not be delayed. There's no question about that. Justice needs to be seen to be done. Judgments should not be delayed. And yes, I know that I have had some judgments which have been delayed. But insofar as far as possible, they should not be delayed. I would add one rider to that. Some people hold a view that just get the judgment out, whether it's right or wrong or it's upside down or whatever, just deliver the judgment. I come from practice. I know what the costs of appeals are to the litigants. And I try to weigh both. And I would also add, I do add to that, is that my appeal rate appears to be very low. I have not had a lot of judgments which have gone on appeal. So, yes, I am aware of delayed judgments, and I am aware and I endorse the need for judgments to be delivered timelessly.
Gauteng is a home for everyone,
Indeed.
with all people speaking all languages.
Indeed.
Beside English and Afrikaans, any language that you think?
I could greet you in Sotho or in French. But other than that, I'm afraid not. And I agree with you that it is better if people, especially living in South Africa, where we have 11 official languages, are able to converse in more than one language. And I think it's immediately a transformative moment if you can converse with somebody in their own language. And as a result of that, I'm a strong believer in that. I'm heavily involved in the transformation activities in the group of advocates to which I belong. And pre-COVID, during 2017, I put in place you could call it a course, whereby we got somebody, a teacher, to come and teach people who were interested to learn Sotho. It wasn't overly successful, unfortunately, because what would happen is somebody would attend on day one, and then on day 2 or day 3, they had to have an urgent consultation or they had an urgent application. But certainly, we just didn't get it right. There was something that we were doing wrong. But it is something that has to be considered and taken forward.
Thank you so much, Chief Justice. I'm fine, thanks.
Thank you very much, MEC. Advocate Madonsela.
Thank you, Chief Justice. Good morning, Advocate Crutchfield.
Good morning,
SC.
Commissioner.
My question relates to your qualifications. I see that you have enrolled twice for an LLM degree,
Yes.
or LLM degrees in, I think, constitutional law and tax law.
They
And
were two- yes.
how did those two courseworks, how did any one of them equip you to be better suited for judicial appointment? 1, 2, what were the difficulties in finishing them?
Excuse me, Commissioner, I didn't hear the last part of your question.
The first question is, how did the two coursework programs that you did equip you for the judicial appointment? And in relation to the second part of the question, I ask you I asked because I'm probably in the same difficulty as you. What difficulties did you encounter in finalizing the thesis pertaining to both?
The second question is, let me answer that one first, if I may. The difficulties in finalizing coursework are simply an absence of time. I still hope to finalize the thesis for the LLM. I have a topic in mind, and there is still the possibility that this will allow me to do that. So I'm hopeful that that can still happen. I haven't abandoned that. In respect of the first one, again, it was an absence of time. And yeah, that's all. But may I please add, I have loved both of those. The first one dealt with constitutional law. There was a module in advanced administrative law and advanced contract law, and then there was privacy. And all of those different areas of coursework have assisted me in my practice, and hopefully going forward, if the Commission will have me, in respect of my work. Then, as regards to tax, I've always been interested in tax. Everything somebody does has a tax implication. And as a result of that, I did that course and I thoroughly enjoyed it. And the issues that we are seeing economically at the moment in respect of stretched supply chains, so we have supply chains through various countries. None of those companies have a head office in any one particular place. They operate off a computer, set up operating off a remote service somewhere. It impacts upon the tax collection in any country. We see that with some of the big Amazon, Google, all of them. And yeah, I've loved all of that work. And although I may not have practiced directly in those particular fields, it's served to inform greater knowledge in respect of everything else that I do. I'll never regret doing any of the courses that I've done. Never. I've learned from all of them. I've benefited from all of them, and hopefully I'm able to use and impart some of that knowledge for the good of others.
Thank you, Chief Justice.
I hope I've answered your questions.
Yes, you have.
Thank you.
Thank you so much, JSC. Judge President Leo.
Thank you, Chief Justice. Good morning, Advocate Crutchfield, SC.
Good morning, Commissioner.
Yes, I'm just need clarity on this reserve judgment of most than another, which wherein they say you took almost a year to hand down the judgment. Can you give the circumstances under which you had to delay, or what caused the delay in you handing the judgment for almost a year?
Yes, ma'am. It was a big matter. That's the first thing. But you may have seen from my application that judgment happened, or the matter was heard in July of 2019. And with effect from September or October of 2019, I was appointed as the pupillage chair at the Johannesburg Society of Advocates. That would all have been fine, except that at the beginning of 2020, we ran headlong into COVID. And the amount of time and the amount of work, regrettably, that it took me to deal with the issues that arose from there impacted significantly upon the delivery of that judgment. I acknowledge that it is wrong. I agree that it ought never to have happened. There's no question about that. But in effect, those are the reasons. If the pupillage chair under COVID hadn't taken place, well, it wouldn't have happened. There's no question in my mind about that. And it's been a very good lesson. There's no doubt in my mind about that. And that will never happen again. And I go back to the question that the Commissioner raised earlier in respect of the delivery of justice. For justice to be effective, it has to be delivered as promptly as possible. And as promptly as possible would be certainly within the 3-month period, and even sooner than that. And you will have seen from my application that I have for my full court civil appeals, I think the one runs at the most to 4 months, and there were circumstances that related to that. But on average, they go out on 2 months. So I've learned that and it's just wrong.
Yes, thank you, Chief Justice.
Thank you, JP. Honorable Singh.
Thank you very much, Chief Justice. Good morning to you and to all the commissioners and admin team, and good morning, Advocate Crutchfield.
Good morning, Commissioner Singh.
I see that you have chosen in your questionnaire on page 11, item 4, to disclose under any matter to bring to the attention of the Commission that you had 2 great uncles. One great uncle, A.E.G. Trollope, who served between the periods 1958 and 1981 in political capacities in the Vervoet/Vorster governments, with Mr. Trollope, your great uncle, ending up as Minister for Immigration and Indian Affairs in the period 1966 to 1968. And then you've also disclosed there that one of your great uncles was Judge Trollope J.A., who served from 1969 to 1981. Now, one can understand that you were very young. You were not even born when some of them were appointed. I'd just like to know, firstly, thank you for disclosing that, because I don't know if our research would have found that out. Why did you disclose that? And have any of their policies and their thinking impacted on your thinking? And then what do you were 16 years old when Trollope J.A. was a judge. So I just want to know how it has influenced your life one way or the other. Thank you.
Well, going back to A.E.G. Trollope, I never met him. And I was born in 1965, so you can see that he died 7 years afterwards. I thought it was right to disclose that he had held the position, and then particularly that he had been in charge of what was then called Immigration and Minister for Immigration and Indian Affairs, and that he served under Verwoerd's government. I wanted that to be on the table and for people to be aware of it. I don't hold with those policies. In fact, they're inimical to everything we do, everything we believe in. But I considered that it was the right thing to disclose. As I say, I never met him. His policies never influenced me. And yes. In respect of the late appeal court judge, he, to a certain extent, he would have been a role model in terms of the fact that he was committed, that although it was difficult under the Vorster government, you still had a liberal wing on that bench, and he formed part of that. His judgments in respect of commercial law still stand today, and insofar as there was a reference made to my diplomas, my qualifications earlier, one of the things he said to myself and my older sister was, education is never lost. You can never overeducate yourself. Even if you don't, excuse me, even if you study nursing and you don't actually practice as a nurse, what you have learned will always stand you in good stead. So to a very large extent, that influenced me. And I think his ethic of service, when he was appointed to the appellate division, as it was then called, his family, he had a wife and children, they remained in Johannesburg, and he worked and lived in Bloemfontein. So his commitment was such, both to the bench, to the judiciary, and to doing the right thing in terms of the law, that he was prepared to make that sacrifice. In effect, I think what I'm saying is that he was a role model.
Thank you very much, Advocate, and I'm sorry that it got you emotional. I'd just like to know. Oh, is it just the cold sniffing of Gauteng?
I am emotional. I'm stressed. I'm emotional.
Yes. No. One can understand that when you speak of somebody that you've lost. Have you had any occasion to disclose this on any public platform?
No.
Or in any speech that you gave or anything like that to talk about this and your relationships?
No.
No.
There are very few people. I never wanted to go to the bar and trade on particularly the late judge's name, or to his two sons were both attorneys, and his nephew was an attorney and counsel. I never wanted to trade on their name. There are in fact very few people who know. There's a handful of people at the bar who know that I'm related to them. The one of his sons, or sorry, it's one of AEG Trollop's sons rather. In fact, I'm sorry, I've given you the incorrect information. It was AEG Trollop who had two sons, and then the two brothers had a nephew. But one of those sons said to me, "You want to go to the bar? Go to the bar. Do it." And yeah, so no. In short, to answer your question, it's not something that's widely known.
Thank you very much, Advocate. Thank you, Chief Justice.
Thank you, Honorable Singh. Advocate Mpofu.
Thank you, CJ. Good morning, Senior Counsel.
Good morning, Commissioner.
Yes, thank you. I just, before I ask my question, wanted to say that I don't think that you needed to disclose your apartheid supporting ancestors, because I don't think that people should be individually accountable for what happened. There were more than 10 elections which excluded African people since 1948. And in all of them, white people by far majority, 80 or 90% voted for apartheid. So you're not more guilty just because you had a relative.
Thank you, Commissioner.
Thanks. Yeah, now coming to well, I think I interviewed you for your silk application.
You did indeed. I'm very grateful that you were present.
Thank you very much. And
Commissioner, if I may,
yeah,
that was the third silk.
I remember exactly that. And I remember speaking specifically about transformation and the initiatives which you have done. And you can see how impressions last. I can't remember exactly what you said, but I remember that it was good. It was, now, more specifically, what I want to ask you about, because as you know my views on transformation, particularly at the bar, the professions general. There is, the fact that it took you 27 years as a junior to have to apply for silk, you know that people are eligible around 12 years or so. So more than double the amount of time that it would take an average male advocate, let's put it like that. To what extent can you attribute that to the gender dynamics of society, particularly when you started, and the fact that there's stereotyping about, what white women advocates or women advocates at all are only good for unopposed motions and divorce and all that, and all that. Yes. To what extent did that impact on retarding your progress, literally? And of course, the point I wish to make is that if that could happen to you as a white woman, you can imagine that the burden is doubled for Black women who have to deal with the gender dynamics and the race dynamics. But let's focus on the gender dynamics, and maybe in your answer, so that I don't have to ask a follow-up, you can say what needs to be done to break those barriers, the gender barriers in particular.
Yes, thank you, Commissioner. Just going back to the burden in respect of Black women, African women in particular, but Black women generally, and when I use the term Black woman, I include African women, Indian women, and colored women. I think they have it worse than white women. But your question is spot on, if I may, Commissioner. I was 24 years of age. I didn't come to the bar with contacts. I didn't come to the bar with a ready-made network. I did what was then in those days criminal pro deo. And I have sent through the list, I'm not sure if it's come through to the commissioners, of the criminal work that I did and the pro deo work that I did. Quality work of a commercial nature was simply not available in those days. I was lucky enough that the late Karen Folks Jones, when I had been in practice for approximately 3 or 4 years, joined our group as leader of the group. And she, to the extent that she was able to, she gave me some of her unopposed divorces and some of her unopposed Rule 43s. But in those days, and to a very large extent still today, if you were female at the bar, you did unopposed divorces, that was all that you were good for. You didn't know about anything that was vaguely commercial. And the result of that is that your skill level is in effect pigeonholed. Your confidence in everything else depreciates. And you begin to think, well, I can only do divorce work, unopposed divorce work, unopposed Rule 43 work, matrimonial type work. And I can remember, like it was yesterday, when I went through for my first silk interview, which I think was in 2013, one of the people on the panel said to me, excuse me, said to me, would you be prepared to act if you were asked? And I said, yes, I would, because I've always believed that we have an obligation. And the comment from one of my very senior colleagues on that panel was that, oh, Alison, do you really think you'll manage? And that, to a very large extent, has been the experience of not only myself, but all of my female colleagues. And you watch as junior male colleagues who are junior to you are get better briefs. And I don't mean necessarily more lucrative briefs, but briefs that are more demanding, briefs that are more challenging, and briefs that are not solely focused on matrimonial law. And that in itself is devastating. There was an incident that one of my young female colleagues told me about approximately 2 years ago. She walked into a court, she had a commercial type matter. And the judge convened the court and said, oh, Miss A, B, and C, we don't usually see you in this court. Now, the judge never meant anything derogatory. I've got no doubt about that. It was just a comment that was made, but the effect of that was the confidence immediately reduced. It evaporated. Her attorney's confidence in her, in respect of that particular matter, evaporated. Her client thought, now his confidence in her immediately evaporated. So one needs to be more aware of the position, I think one needs to be more aware of the position that women find themselves in, even 30 years on, and of the effects of what has gone before. In respect of your question, Commissioner, as to the delay, how it's retarded my progress. Because you only deal in matrimonial law, your judgments are not reported. So you don't find yourself in the law report. You don't experience that sort of, you don't become known by way of your judgment. And when I went to what was my second sort of interview the following year, I was told that what reported judgment? And I said to the gentleman concerned, have you even read any of them? Well, no, he hadn't read any of them. And all of the reported judgments that I have from practice make some contribution, but they weren't commercially based judgments. They weren't for wealthy clients, and he hadn't even bothered to read them. So there is no question that progress in terms of work quality, progress in terms of just moving up the ranks out of matrimonial law and the like is retarded simply by the fact that you are female. There's not a doubt in my mind about that. And we're still seeing the effects of that today. And yes, the burden on our African women, our Black women, is significantly worse. But there's one more thing that I wanted to add. And I forgot what I was going to say. I've lost my train of thought. But Commissioner, it is an extremely valid point here. What can we do to correct it? We've got to end the scourge that is gender-based violence. There's no question about it. I'm a great believer in education. We can't have every woman being a doctor or an accountant or a lawyer. But if we can reach a position in our society where we can educate every single young woman, keep them in school for longer, put them in a position where when the boyfriend, husband, the partner starts to hit her, she doesn't have to stay. She has enough confidence in herself. Her skills have been developed to the point where she can take the children, she can leave, she can put a little roof over her head, food on the table, and just keep her and her children out of that environment. This body, this commission, has the power to make the change. We need more women. We need more women as role models on the bench. We need to be able to show we are struggling to keep our women Black, white, Indian in practice. I think the attorneys manage it better than we do, but our statistics in respect of women from approximately, well, now with COVID, it's basically from year one. They're decreasing, notwithstanding the work that we put into trying to develop them and keep them in practice. We need more role models. We need people, we need society to change, to see women are not only good for being in the home, they are more than capable to entrust them. And this is the body, in my view, that has that ability to do so. And I think we have an obligation to do so, to make the change, to bring in more African women, more Indian women, and even more white women. We need more women. That's my plea to the commission. And please let people give more women better quality work from as early in a stage in their practices as possible.
Okay. Thank you, Advocate. Thank you, CJ. On a lighter note, I'm glad that your third silk interview went much better. And I'm proud. Thank you.
CJ, can I take a follow-up, please?
Please go ahead, Honorable Lucas.
Thank you very much, CJ. Good morning.
Good
Judge,
morning.
as a Crutchfield, I don't have my glasses. So I was listening to you attentively, and I'm sure if you have watched the interviews last week, you would have seen that that is something that is very close to my heart, particularly since we had that exercise as Parliament where women felt that there is really a lack of compassion in your profession, particularly those that are in front of courts and also those that are aspiring to become advocates and judges. Now, at a very structural level, in your own practice, what have you been doing to make sure that you empower, particularly Black women, to make sure that you have also made a contribution to those things that you are so passionate about, that we can make a difference? Thank you.
Commissioner, thank you. If I can go back to the point that you raised in respect of empathy. I have stood in courts at 24. I've been overlooked by judges. I've been humiliated by judges. And I know that terrible fear of being young and being female and being terrified of being in a court. I can remember that like this yesterday. And I see that fear in front of me when I act on the bench. And people have spoken about my temperament, my empathy. I try desperately to bring empathy to our young female practitioners. I can see that my own terror playing out in front of me. I have actively tried to bring that into all my acting stints, and I shall continue to do that for so long as I can. In respect of my own contribution towards empowering our African women, I've been involved at various levels. We have, as I'm sure you know, the society of which I'm a member, and then we practice in groups. And I practice in a particular group. I have worked actively within that particular group to uplift our African, our Indian, and our colored women. We, over and above the language course that we tried to implement, I've also managed a skills upliftment, because we need to have a transfer of skills. And we've done that in two ways. We've done that in terms of making opportunities available to our youngsters, and those opportunities come together with a payment that is sufficient to keep them in practice. We've had to reduce that payment because of COVID, but it is sufficient to help them along. Now, in respect of our information, and I don't want to call it a lecture program, because it's not a lecture program. It's an information, it's a discussion, and it's an attempt to enable our young practitioners to get their practices up and running and to keep them in practice. That is the goal, that's the ideal, to keep them in practice. So we start with a course on, well, not a course, a talk on practice management. Respond to your telephone calls, answer your emails, don't wait a week to answer your email. The attorney's waiting to hear from you. Tell him that you've read his brief. A talk on ethics, and a talk on tax and VAT for advocates. Not a course, not a talk on tax so that you can go and lecture tax, but just as an advocate, you need to go and make sure you register with SARS. Make sure that you have two bank accounts. Make sure that when the time comes, you register for VAT. Fees, how do you charge for your fees? And we assist them with that. Once we've got past those introductory issues, we then focus on, if you get a call in the morning, Tuesday morning, 8 o'clock, an attorney wants somebody to do an insolvency application. What do you need to know? What are the things you must find in your brief? What are the essentials that you need? Same with things like bail. All those disciplines that will assist our youngsters, so that if somebody does approach them, they're immediately able to run with that particular matter. It gives confidence, and it enables them to deal with whatever it is that the attorney wants. So I've run that. Insofar as the actual skills of becoming involved in work, we do it in two ways. We have a fund to which we all contribute, and I have gone out of my way. I wasn't one of those who had briefs which came included with juniors. So I've had to find other ways. And what I've done is I've leveraged my own contacts. When people have come to me and said, please, I need help with a brief, can you help me find something? I've gone out and I've leveraged my own contacts and said, please, I need you to help somebody with an opportunity to come and assist you in a brief. And there was a joke in my group at one stage. If you see Alison, avoid her because she will ask you if you have a brief that you can accommodate somebody, if you're willing to give a talk, if you can help somebody with something else. And I can give you an example. So the bar has something called the Rule 7. And each member above a certain standing has to engage with another member, bring another member from a different group that you aren't acquainted with, and bring that member into a matter. Anyway, I kept contact with a lady with whom I was involved last year. And I had contact with her last week or the week before. And she just said to me that practice is very difficult. And she's an African woman, and I know that she's a single mother with children. She just simply thinks that things are not good. And I said to her that I know what work she does. I know what she wants to do. And I said to her that I will make some calls. I can't promise her that I'll be able to find her something, but I do promise her that I'll try. And I'll take some time this week and take some time next week to get her something, to try and keep her in. It's exposure, ma'am. It's empathy. It's giving people that confidence and giving people that opportunity. What we try to do, and I'm taking up everybody's time, but one of the aims of our skills development is bring somebody into a matter. So there is an attorney that's involved. Hopefully, the attorney will bond, for want of a better word, develop a relationship with the youngster, and the youngster will then in turn benefit from work that flows to the youngster. And we are seeing some success, I'm happy to report. But things are tough with COVID. The amount of work that's available has diminished. But we're trying.
No, thank you very much. And then in any case, practical things appeals to me that I can tell you. Thank you.
Chief Justice, I have a follow-on also arising from Commissioner Mpofu's question, if I may.
Please go ahead, Advocate KNSC.
Thank you very much. Hello, Alison.
Good morning, Commissioner.
I recall that when we interviewed you and you were recommended for Silk, I think it may even have been me that expressed a concern that you should in future get involved in bar-related work. And you've given a detailed answer of the work you've given in your group since you took Silk, but you haven't mentioned adequately, and I think you would do yourself an injustice not to mention it, that you did in fact become very heavily involved in bar-related work after taking Silk. Not a long answer, but if you could just outline what you did, please.
Yes, I'm sorry about my long answers, but I acted as the pupillage chair last year, and I was heavily involved in operating that program, giving effect to that program. And the short answer is, we very quickly reformatted our lecture program for our pupils so that we no longer had in-person lectures. We had remote lectures. Together with the vice chair on the Bar Council, we were able to ensure that all of our less privileged members had access to data. So everybody was able to listen to their lectures. And what we did was we recorded every one of those lectures with the lecturer's consent. Those lectures are stored, and we made them available to bars that have requested them, Polokwane in particular. has made use of those stored lectures because they don't have a lecture program that's as comprehensive as ours. But that wasn't sufficient because we also run an advocacy training program, and we have to reach a certain point in order for the attorneys to commence with their conversion process. And we managed, fortunately, to reformat our advocacy training program to an online program, and it's still running today as an online program. It has required a substantial additional commitment from our members because whereas previously we used to have nine or 8, 10 pupils in a group, we now have 5. So I participated in our advocacy training, and I'm sure Commissioner Mpofu and Commissioner Kane were there over the weekend as well. We had 5 pupils in our group. We had 3 members. So myself and 2 of our colleagues. In some of the other groups, we have judges, but I was so proud of them. They did so well. So yes, it was an enormous amount of work. Come September, we received 207 applications for pupillage for this year. We interviewed, and I led that process over 2 weekends. We interviewed 200 of them. And it's a monumental task, but we did it. In addition, we have reviewing teams which review, without an interview, every single application. So suffice it to say, thank you, Commissioner. I followed on from you, but we worked extremely hard and we had a measure of success, and hopefully we can continue building on that this year.
Yes, you did. Thank you very much. Thank you, Chief Justice.
Thank you, Advocate Karen. Commissioner Dlepu, Matolo Dlepu.
Thank you, CJ, and good day, Advocate.
Good afternoon, Commissioner. Good morning.
Okay. I've been listening to the challenges that you have been facing and women are facing in the bar. And I tend to wonder, what can women themselves do to change that, those who are in the bar? I'm saying this because one of the things that the Legal Practice Act is seeking is to have access to the profession. And it looks like the bar councils actually are not actually doing much about that, especially the society that you belong to, that actually does not want people who did not serve pupillage with them having the chambers in the same building that you have. For me, it does not reconcile. I can't understand why, because by doing that, you're excluding the people you're talking about. I mean, you say you have interviewed about 207. And how many of those 207 your Society of Advocates is able to take?
I can give you the statistics, ma'am, Commissioner. We have this year, we only have capacity for 70. Please keep in mind that our pupils pay a minimal amount for their pupillage. We are not like Lead SA, which gets paid for the work that they do. So we have limited amount of resources. We have 70 pupils at the moment, and I can give you the breakdown. We started off with 80, but 10 dropped out along the way. At the moment, females, we have Black, Indian, and colored, we have 28. White females, we have 18. Males, African, Indian, and colored, we have 24. White males, we have 8. So there is, within the capacity that our resources provide us, we emphasize African people, Indian and colored, over white people. And certainly not only in terms of race, but in terms of number. there is an emphasis on previously disadvantaged people, and giving those people access to the profession and trying very hard to assist them for so long as possible. Insofar as you refer to chambers, we will accept anybody who is properly qualified. We have many people doing pupillage in Polokwane and joining us. There's no difficulty with that. They're admitted advocates. In effect, we have the same requirements as the LPC. The LPC requires that advocates do a theory course, that they do a practical course, that they write an exam and they pass it. We have the same requirement, and also the LPC wants us to register, which we do, and pay our dues, which we do. And we don't have anybody who is properly qualified, who does pupillage within the GCB, not necessarily with our society. Polokwane, Limpopo, you're free to join us. And so I disagree that our policy is anti-transformation. Within the resources that we have available to us, we take as many pupils as we possibly can. Our members give of their time freely and voluntarily. Our lecturers lecture, they don't get paid, they volunteer. Our people who who mark legal writing exercises, they volunteer. The advocacy trainers, they volunteer. We call upon a huge number of members to come and do your duty, to come and help, assist our pupils and assist others in giving them access to the profession. I agree with you that we need to broaden not only access to the society and to the GCB structures, but to access to the profession as a whole. There's no doubt in my mind about that. There is a desperate need for legal resources, for legal advice in our rural communities, and we need to be in a position, the profession as a whole needs to be in a position to service that.
Just a follow-up. As you agree with me that you need to broaden your intake, or make sure that there's access to the profession, what do you think you can do as a society of advocates? What do you think can be done, or you can do, to make sure, because out of the 200, there's 1,000 more who can't find pupillage. What do you think we should do combined? I don't want you to be talking about the LPC as another body, because all your body falls under the LPC.
Yes,
so what
absolutely.
can we do to do that?
Ma'am, regrettably, our limited resources are a problem. But there is a thought that instead of, for example, us giving coursework lecturers, theory lecturers, that a school is set up for pupils where they can do their theory, perhaps for 6 months, and then they can go off to the different organizations, because it's not only the GCB structures that are involved in pupillage, there are also all the independent structures that are involved. We just don't have the capacity to train all of the potential advocates in the country. Our members are, as I've said, free, they're volunteers. We have limited resources. Possibly, if the LPC or if the Department of Justice is willing to pay, we can make an arrangement. I think the point I'm making is the GCB, the JSC, and obviously I don't represent them here today, but I have no doubt that they would be amenable to assisting. May I interrupt myself to say that the funding that the LPC has made available to pupils this year throughout the country is of enormous assistance. There's no question about that. The pupils who've received it are enormously grateful, and it will serve to assist hugely. But we need to extend, just going back to your original question, if I may, we need to extend access to learning throughout the country. It's a concern that I have in respect of the fact that the GCB isn't accredited for for pupillage. I'm very worried that it's going to lead to a weakening of the rural bars. I'm concerned about that on a long-term basis. But we need to increase access and capacity at those bars and at the independent associations. Extend the reach of the independent associations so that there are more opportunities available to potential advocates.
Thank you, Chief Justice, and thank you very much.
Thank you, ma'am.
Thank you, Commissioner Dlepu. Honorable Magwaneshe.
Thank you very much, Chief Justice. Good day, Judge.
Good morning.
Yes. Can you enlighten us about your commitment to the culture of human rights before 1994 and after 1994? I can see from your CV you graduated in 1986 with a Bachelor of Arts degree. It was during a time when it was very turbulent in our country. Were you involved in with any community organization during that time? And then after that, what did you do?
I wasn't involved directly. I can't say that I was. I was involved insofar as I witnessed what went on around me, and I was a VIT student. I saw and I heard what went on, and I think we were all greatly troubled about it. I have a fear of crowds as a result of some of the things that I witnessed on campus, and I can still remember exactly where I was standing when the last state of emergency was announced in the late 1980s. So I can't say I was actively involved in anything, but being at WITS gives you a greater awareness. There's no question in my mind about that. And my awareness of social issues in particular, of the issues that women have in society, and now I'm in a position where I've experienced them myself, gave one a greater awareness of that.
If I may proceed, Chief Justice, the last question.
Yes, Honorable Magwaneshe, go ahead.
Thank you very much, Chief Justice. I've been looking at your CV. I think it's a follow-up to Advocate Madontela's question. You finished the coursework for your LLM in 2007. And then the thesis was outstanding. Then you started, and then you did the advanced program in insolvency in 2014. Then you started with LLM in tax law, 2016, 2017. Thesis is still outstanding. Then you continued doing other courses. Another person would say it's not the question of time, it's a question of prioritization.
Excuse me, sir, the question of?
Prioritization. And that person would also link that with the outstanding or reserved judgments. Can you put us at ease that it's not the issue of just prioritization? This CV would not reflect you as a judge in terms of timeless delivery of judgments.
Yes. Commissioner, if I may, if one looks at the curriculum vitae as it appears, one will see that 2007 was the coursework for the first LLM, and the next course was only in 2014. So it's not a case that I simply abandoned the thesis and then went on to do the insolvency litigation. I still hope, certainly in respect of the LLM coursework, to finalize that thesis. It's not a case that I've abandoned it altogether. I certainly haven't. In respect of your reference to the the cyber law and the competition law in the following year, I can see where your question has its source. But those courses were both done at WITS, and WITS only offers, they don't offer them every year. So if I hadn't done the competition or the cyber law, I may not have been able to do it. There's no certainty that they will definitely offer it the following year. And that's why I elected to do those two at that point. And there are two things that I've always been very interested in. I think cyber law is where the future lies, and competition law, I'd always had an interest in it. And the pension law was another thing that I'd always had an interest in. And one can see that it was only the attendance course, it wasn't the exam course, 2019. And that is simply, and you've referred to the outstanding judgments that took place in 2019 and subsequently into 2020. The one commenced in 2019. I originally started that course with the exam course. And I realized during the year that I just wasn't coping. And I had to downgrade that course to the attendance course, which was unfortunate. That ties in with the workload. It ties in with becoming the pupillage chair at a later stage. And already at that stage, I was actively involved from the end of 2018 on the Bar Council and already tasked with a significant portfolio there. So it was a case of where was the master, and certainly my bar work, the importance of what I was doing for the society and for the membership overrode the importance of the thesis for me personally, and doing the exam course for the WITS pension course. I'll go back to that LLM in respect of the tax course. A friend of mine who was also involved in it has just submitted hers recently. So I haven't closed the door on that at all. I haven't abandoned that. It's not a character flaw, but I understand your concern. I hope I've answered your question adequately, Commissioner.
Thank you very much, Judge. Thank you, Chief Justice.
Thank you, Honorable Magwanishe. Colleagues, I thought I would raise this after the candidate is gone, but at the rate we are going, with 8 more candidates to go and a meeting scheduled for 6 p.m. tonight, I think we've got to reflect on how we really want to proceed. We're not making progress, the kind of progress we had agreed to make. Commissioner Tsepe?
Thank you, CJ. I will assist you and not ask any question. Thank you.
Thank you for assisting the process, Commissioner Tsepe. Prof?
Thank you, CJ. To a large extent, Commissioner Mgwanishe asked the questions that I was going to put. I just want to ask one follow-up on that. The Muster judgment that was outstanding for that period of time, specifically also during the period that you did pension law. It's just for curiosity's sake, is it because you were dealing with pension funds in that case that you also decided to do the pension law courses, or is that just coincidence?
No, that was just coincidental. And the pension funds, well, the pension fund aspect enhanced my interest in pension fund, and the pension fund course enhanced my interest in the matter. So that is coincidental.
Thank you, CJ.
Thank you, Prof. Commissioner Barnett?
Thank you, Chief Justice. Good afternoon, Advocate.
Good afternoon.
My question is just on the Muster judgment. Having spent such a long time in preparing the initial judgment, let's say close on a year, one takes the point that it's a long, the record was quite long, I mean, 1,600 pages, etc. So that point is well made. The question is this, having heard that and then hearing an application for leave to appeal, having spent such a long time with the matter, would you not have at that stage have had a good idea on hearing the argument in the application for leave whether or not there was a realistic chance of success and on the prospects of success, than to take a further almost 3 months to deliver that answer or that judgment.
Yes, I'm aware of it. The application for leave to appeal raised additional information and, well, not additional information, additional illegal points that were, it wasn't confined, let me explain it this way, it wasn't confined only to the issues that were raised in the case originally. In fact, one of the points that was raised by one of the parties was that the applicants had moved away from what they had argued originally in the main application. And there was new case law that had to be considered as well, and so on and so forth. But the point is that the arguments were not located solely on what transpired in the original application.
So given those facts, you're still happy that it was a reasonable time it took to grant that judgment?
It was an important judgment for the parties and, well, to me as well. And the issues are not easy.
Thank you very much, Chief Justice. I'll also drop the second question.
Thank you very much, Commissioner Barnett. Advocate Crutchfield, SC, you're excused, ma'am.
Thank you, sir. Thank you to all the commissioners